call the subcommittee back to order, and I want to thank the witnesses for their patience. I believe we are now to Mr. Isaacson. So, Mr. Isaacson, I would invite you to begin your testimony.
Thank you, Madam Chair and members of the committee. On behalf of the Direct Marketing Association and its more than 4,700 member companies, I want to thank you for the opportunity of testifying today and to discuss with you serious concerns that I have both as an attorney who has practiced in the field of sales and use tax law for more than 20 years, and also as a teacher of constitutional law at Bowdoin College. I have serious concerns that the bill which this committee is considering would undermine core constitutional principles that have served this nation well for more than 2 centuries, and would also erect a tax compliance barricade across the electronic highway to the detriment of the very small businesses and medium-sized businesses that have had the opportunity to access the unified national market that the Commerce Clause has created. Advocates of the STA have stated that they believe that it is worth abandoning these constitutional principles because of the lost sales tax revenue that they believe that they are suffering. The real problem is that the numbers that are used are totally illusory, and Mr. Cannon referred to the discrepant numbers that exist between the University of Tennessee study and the recent study that was undertaken by the Direct Marketing Association. And the question then becomes, why are these figures so different? And I think that there are 3 basic reasons. The first reason is that the growth of electronic commerce just has not been the rocket sled that was predicted in the University of Tennessee study. The growth rate has been much more modest than those predictions anticipated, and that fact has been admitted by the authors of the study. The second reason, and one which is oftentimes missed in this discussion, is that 90% of electronic commerce, these huge numbers that you hear, are business-to-business sales. And in the business-to-business sales community, there is very little loss of sales tax revenue. And that's because most of those sales are either exempt sales that are made as sales for resales or sales in connection with the manufacturing process, or businesses self-report their tax liability to state revenue departments. A recent study undertaken by the Washington State Revenue Department reported that for internet sales that are made between businesses, 85% of the sales tax is in fact collected. So the notion that there is this sieve of lost revenues is not accurate, even when you look at what the overall volume of internet sales may be. And perhaps the most significant reason why the University of Tennessee study is inaccurate is because of the fact of multi-channel merchandising, which has really become the predominant clicks and bricks phenomena that, again, Mr. Cannon described. Most companies that use the internet to expand their market, develop brand equity, provide customer service, find that it is to their advantage to open retail stores or other customer service facilities, create nexus in states, and then commence use tax collection. In effect, the problem that has been described is largely a self-correcting one. And certainly much of these figures that were described for Cyber Monday are by companies that are clicks and mortar retailers are collecting the tax. In that regard, the issue is simply not one that reflects the kinds of numbers that are frequently bandied. And I think we need to be very cautious before surrendering long-established constitutional standards based upon illusory figures. In my opinion, the Streamlined Sales Tax Project has been the wrong approach to this issue. Unlike most uniform laws, which are submitted to the Uniform Law Commission, that consists of distinguished jurists, law school professors, practicing attorneys, and has produced such works as the Uniform Commercial Code, the Uniform Division of Income for Tax Purposes Act, the famous UDIPTA law that state tax practitioners are very familiar with. That process wasn't followed in this instance. Instead, this was essentially a government-only exercise. And I think in being a government-only exercise, an agreement negotiated by tax administrators for tax administrators, the project failed to take on some of the key areas of needed tax reform that had been recommended to it by the previously congressionally authorized Advisory Commission on Electronic Commerce and by the National Tax Association project that looked into this same issue. So, for example, the project early on abandoned the idea of reducing the more than 7,600 different tax jurisdictions in the United States. It failed to address the issue of one rate per state. It failed to address the issue of having a single audit for companies that were registered under the agreement. It failed to come up with even a uniform definition for selling price, which is the core concept that underlies the application of a sales tax rate. The fact that these issues were simply not addressed because state laws were already too discrepant to reach conformity on those issues shows that there was a low bar that was established at the beginning of the project. Perhaps even more problematically, however, is that the STA has been a moving target. It's had more than 70 different amendments since it was adopted in 2002, and most of those amendments have been for the purpose of diluting or simply eliminating conformity provisions that were previously in the original agreement that was adopted. That is not the right direction for sales and use tax reform, and there are 20 more amendments that are going to be considered by the governing board at its meeting next week in Dallas.
Mr. Isaacson, your time has expired, but hopefully we'll be able to follow up with your testimony during the round of questioning.
Thank you.
Thank you so much. At this time, I would invite Mr. Rauschenberger to begin his testimony.
Good afternoon, or good morning still, I guess. I appreciate the opportunity to be here. I'm Steve Rauschenberger, past president of NCSL, a former assistant Republican leader in the Illinois State Senate, a third-generation retailer and an accountant by education. The National Conference of State Legislatures is a bipartisan national organization representing every state legislator from all 50 states in our nation's commonwealths, territories, and possessions in the District of Columbia. I'm pleased to have the opportunity to appear before you today in support of H.R. 3396. But I have to tell you, despite spending 15 years in the Illinois Senate, much of it in hearing rooms and chairing the Appropriation Committee for 10 years and testifying in Congress on 4 separate occasions in the past, I'm nervous today because today it's not just a good idea I'm representing the work of hundreds of people who have devoted literally thousands of hours of effort and compromise to try to figure out a way to bring the states together. The active involvement, I'm representing the active involvement of 35 states through their legislative leaders and the executive branches. More than 37 states have taken action in both chambers or through executive order to participate in this process. I'm commenting in favor of what I think is the most important piece of legislation to sustain, to reform, and stabilize our world-admired system of federalism, the 50 sovereign states and an indivisible union that I've ever been involved with. So if I'm a little nervous, it's because I care a great deal about this issue, and it's much more important than I think people realize. You've heard a lot about the substance and the structure. Maybe, I can touch on some of the softballs that need to be batted out of the ballpark a little bit. What this bill in combination with the streamlined sales tax agreement does is it levels the playing field. So businesses that play by the rules, that have been traditional retailers, are treated equally with everybody using cyber to a sort. I'm in favor of internet retail. I think it's a wonderful thing. It expands the assortment. It strengthens the American economy, but we should have a tax system that treats all transactions like transactions in similar ways from a tax point of view. The streamlined sales tax, together with this bill, provides stability for state and local revenues. So whether there is a treasure hidden somewhere under the sand or not, equity doesn't require justification. I mean, that's what our tax laws should be pursuing. This provides both administrative and liability relief for businesses that adopt the modernized sales tax. States accept the responsibility to compensate retailers for the cost of collection. The bill includes protections for small retailers who have sales of less than $5 million over the internet, so they don't have to come into compliance with this. It retains and protects state sovereignty and tax competition between the jurisdictions, which is something we all believe in. It retains local governments' rights, if states grant it, to impose sales taxes on their own. And it recognizes in a way other things don't, the political realities of adopting reform in a complex economy and a complex country under our laws. Taxes are never popular. However, as state and local governments are to have the necessary resources to provide education and homeland security and public safety, then we need to maintain their ability to levy taxes. In surveys across the nation, the tax that's least disliked surprisingly, is the sales tax. When you think about it, sales taxes, when they were first imposed in the 1930s, customers bought goods from local merchants. There were very few remote sellers. In the 70s and the 80s, we saw more goods being sold by remote mail order sellers and without collection of tax. This was adjudicated in the court cases of Bellis Hess in 1967 and reaffirmed by the Quill decision. What we've tried to do rationally since 1999 is pull together legislative leaders and business leaders, executive branch, tax commissioners, and try to come up with a solution to the change in commerce that adopts state laws. This is not replacement of sales tax law in the 50 states with some new model act, which maybe the UCC would be. It's a convergence of state policy. It's complicated necessarily because it's designed to protect and to defend state sovereignty. At the same time, it provides local options and local resources. I'm going to wind up real quick because I could tell you a lot. I could do this for about 45 minutes and probably bore you to death. But let me end by reminding you, it's wonderful that the Uniform Commercial Code went through the Uniform Group on Laws. I think it took about 40 years from the beginning of the adoption of that to its last adoption. We are in an internet age, and the challenge is, are states going to be able to conform and to change and adapt to the changing environment, whether it's their taxes, whether it's a regulation of professions, whether it's a regulation of insurance? This is a fragile flower of reform that's been brought along by people working very hard. I hope you treat it delicately. I hope you treat it thoughtfully. I couldn't disagree more with some of the representations from the previous distinguished speaker, and if we get to him in questions, I'd be happy to try to knock some more out of the park.
Great. Thank you, Mr. Rauschenberger. We'll now begin our round of questioning, and I will begin by recognizing myself for 5 minutes. My first question is for Ms. Wagner. In establishing a uniform set of rules, one of the heated discussions that a uniform rule is the issue of sourcing for sales taxes and whether the taxing should be based on the destination of the goods or the origin of the goods. As the Secretary for Revenue of Kansas, and knowing that Kansas has altered its sales tax system, what insight can you provide about the change from destination to origin sourcing?
It was painful. I think the concept of using destination sourcing makes sense, but it does require an adaptation on the part of, in Kansas, about 25% of our retailers. And we had to provide the rates and boundaries database. We had to provide consistent assistance, and I'm still sending some of our technical staff from Revenue out to companies that deal in many jurisdictions. We have 750 jurisdictions. We made the conversion because all of us believed, from the governor to the Republican and Democratic leadership, that this was an appropriate thing to do. But the political reality is that there are 10 states or more, that some of which are associate member states now, that have tried and simply cannot get that done. The state of Texas is very interested in being part of this. They were involved from the very beginning, but they don't see this as politically possible. So we are now considering on the governing board next week an option to allow for origin sourcing in state and uniform among any state that would adopt that. So it would be an addition to our sourcing rule. It would still be uniform, so you won't have all origin states doing everything differently, but one rule. And then for the remote sales, either destination sourced or the other proposal that's being considered is a single rate. And we will be debating that and making a decision. I think the political reality is it simply is not going to accommodate all the states that need to be there with the rule that we have in place. The state of Washington has its deadline for making its conversion on July 1 of 2008. Arkansas has made a conversion. Iowa made some changes, but Ohio has been unable to do it. Utah has been unable to do it. Tennessee has been unable to do it. And we're trying to adjust so that we can bring in these other groups. I hope that's sufficient.
Yes, thank you. Mr. Zakreski, some opponents of the SSUTA and the legislation that Mr. Delahunt has introduced argue that the collection and remittance of sales tax by remote sellers would impede electronic commerce. And I know that you are a representative of a company that conducts business online. So in your experience, would the requirement of collecting and remitting sales tax impede electronic commerce?
It shouldn't impede electronic commerce. Today, you have to have a system that takes your order and records it and tells the customers what the price is. With the Streamlined Sales Tax project, the project provides software and certified service providers that will come in and attach to your system and collect the tax and tell your customers how much that tax is. So to me, it's really not a legitimate concern that would impede commerce, because not only can you do it, you're doing it at least in the state where you're located today, and the software to do it for multi-state is free.
So with emergent technology, you found a solution to that particular problem.
That provides a solution to these sellers.
Thank you. Mr. Isaacson, is there any policy reason why the medium through which a particular good is sold to the consumer should dictate whether it is subject to sales tax? And the question specifically is there anything about the internet that suggests that the sales of goods ordered over that medium should not be taxed?
The issue is not whether goods should be taxed if they're sold over the internet or not. As I pointed out before, multi-channel merchants who are selling over the internet, such as JCPenney, are collecting, and a large number of the largest companies are in fact doing so. So that's not the issue. The issue is whether a company that has no presence within a state, does not benefit in any way from any services being provided by that state, does not get tax increment financing for building new facilities or getting bypasses and access roads built to its stores, who has no political role in that state, whose employees are not voting in that state, whether it's appropriate for 7,600 tax jurisdictions to be able to export their unique and non-unified tax systems across their state borders to 49 other states. That's the issue the Supreme Court has repeatedly addressed and has said that the Commerce Clause protects commerce from that kind of approach. It also happens to be the reason the Commerce Clause was adopted in the first place. What was happening in 1787, and the reason why the convention was called in Philadelphia, was because states were imposing tariffs, duties, and taxes on each other's trade. And the country was going into a depression. And the Commerce Clause is what created the unified market to prevent that.
Thank you. I see my time has expired, so I'll recognize Mr. Cannon for 5 minutes.
Madam Chair, would you mind if I deferred my time until the end?
Not at all. We may do second round, though, depending on the interest of questions. So you may want to take your time.
I shall do everything in my power to help us get done in one round.
Okay. Mr. Delahunt, you are recognized for 5 minutes of questions.
Yeah, I'm going to direct, thank you, Madam Chair. I'm going to direct my question to three panelists other than Mr. Isaacson. Mr. Isaacson made the statement that this was a government exercise. The implication being that there were a bunch of bureaucrats stuck in a corner someplace. At least this is the way I interpret it, and maybe I'm mischaracterizing it. But would you explain to me, maybe there was some academicians that weren't allowed in, or maybe even a professor of constitutional law at a fine institution, a small Ivy college up in Maine, didn't participate. But the point is, I think it was misleading, because, and why don't I address it to Secretary Wagner, how did this come about?
Well, I think
What was the process? I know you've had numerous amendments, and I congratulate you, by the way, on having numerous amendments. I think what that reflects, at least from my vantage point, is an effort to get it right and to do it well and to attempt to look at a very complex problem and to achieve a balanced resolution.
And I think that is exactly correct. It started out with governors, state legislators, and business representatives, as well as tax administrators. The members of the governing board are selected by the state. Some of them are business representatives.
If I may, Madam Secretary, the National Governors Association, I know in the past has taken a position on earlier versions of the bill that's before us. Are you aware of their position on this particular legislation?
Yes, I am. We work very closely with NGA, NCSL, Federation of Tax Administrators, all of the organizations, and they support.
What's their position on this bill?
They are supportive of this.
Do you know how many of the governors have indicated their support for this particular or earlier versions of this legislation?
It's a little difficult for me to answer that because governors keep going in and out of office.
I know, they keep coming and
going. Governor Leavitt was a good example of a leader early on who's now no longer in that position. But the fact that 22 states have embraced this legislation and governors have signed it, there's a minimum of 22 and probably 10 more that were involved earlier. The NGA has consistently had a position on this legislation in support of it. And that is true also for the National Conference of State Legislatures.
Let me go to Mr. Rassenberger and ask him to respond to both of those questions.
I'm happy to have the opportunity because I don't think it's the only thing Mr. Isaacson got wrong. I have been involved since 19...
Don't let me inhibit you.
No.
Get wrong?
You know, state legislators, you shouldn't let us near microphones anyway. Since 1999, I have been a co-chair of a task force that NCSL has had to work on this issue. I have never participated in a meeting that wasn't a public meeting. We spend more time with members of the business community. It's why we have so much broad-based business support. There's only a single association I'm aware of that they looked hard to find that was in opposition. So to say that this was done by bureaucrats, this was done by elected officials and people representing the business community together with people who understood the tax system, which makes sense to me. To the question of support, NCSL has supported this effort since 1999, which requires a majority, I think 70% of the 50 states to be in support at all times. For us to have stayed in continuous support of this. We have had a lot to do with drafting it. And I think the number I recall is, I think it was Franklin presented more than 50 changes to the Constitution before it was finally ratified. The amendment process is about seeking perfection, not about confusion about goals.
Yeah, and let me just make a comment too. I think you said something here that's very significant. We do have a unique system of federalism here. And I think it's very important for this Congress to respect federalism. I happen to embrace the concept of devolution and states' rights. Sometimes I'm surprised at my colleagues of your party that seem to believe that Washington knows best in terms of what the states ought to do or ought not to do. But out of respect for the states, I think it's important that we understand that this is about sustaining that system of federalism and conferring to the states the power to raise revenue, which is justifiably there. I want to commend you. I want to commend you all for really a tremendous effort and for the significant progress that you've achieved. I wish we could do the same here in the United States Congress. And with that, I'll yield back.
Gentleman yields back. Mr. Cohen is recognized for 5 minutes of questions.
Thank you, Madam Chair. First I'd like to say hello to my former colleague and friend, Mr. Rauschenberger. It's good to see you.
Good to see you.
My state
you look taller and better now.
It's Congress. We have a great basketball team. It's all 7-4. Tennessee is a state that's heavily sales tax reliant and yet has been somewhat reticent maybe to become a full-fledged member. And I probably should know the answers to this, but can you tell me why Tennessee, a state so starved for revenue, is an associate member and hasn't joined in?
The sourcing complications of the local jurisdictions has been a hard bite for both chambers in Tennessee to embrace. Most of the states that are having trouble coming into compliance, it's around the changes required and the risks that are assumed by the local jurisdictions in the sourcing change and its effect on local revenues. States that have kind of bridged that gap have done it. I think Washington is one of them, which actually directed the set aside of a major portion of the new increment revenue and used that as a hold harmless to kind of solve the local jurisdictional problems. But that's my best understanding right now.
And we've got, I've thought about this issue, and of course, Mr. Isaacson, I read your statement. I got a little, but there's a lot of revenue that your brief, or the brief that's attached to it, questions how much revenue the Tennessee study suggested we might be losing in Tennessee. But there's considerable revenue, and there's the years to come of revenue. And you have a state like Tennessee, and there are only a handful that don't have an income tax and are reliant on the sales tax. It really does deprive people of basic services because you've got a regressive tax system. And if you're going to have a state, Mr. Islington, with a regressive tax system like Tennessee has and others, without any major source like oil or gambling, Nevada, Texas, and those other states that don't have any income tax, how would you suggest that they survive in the future years in providing services to people that need education and health care and help with their utility bills? Should they just kind of let e-commerce grow and grow and grow and their sales base just decline? Or?
It's a fair question, and I think that there's a clear answer to your question. I think the starting point has to be understanding what are the numbers that we're dealing with. If you look at the United States Commerce Department figures in regard to those states that are currently full members, and based on that Commerce Department data, the lost tax revenue is $145 million. So dealing with what is the scale of the issue, I think, is significant. One of the reasons why Tennessee has not wanted to participate in this process is that Tennessee has had different tax rates for different kinds of products, agricultural products, heavy equipment, for example, different tax rates, and not wanting to conform to the tax regime or protocol that the SSUAT has called for. That's part of their sovereignty. That makes sense. The real reality is that this problem is largely self-correcting because companies do start collecting as they expand their businesses. The incubator is electronic commerce. The long-term business plan is to leverage brand equity, establish retail stores, provide after-sale customer services, and by doing so, establish nexus. That's what we're seeing in all of the major large retailers, and I think it's a development that says that we don't need to be concerned about the future in the manner that's been described by my co-panelists.
Well, I hope you're right. We've been waiting for Saks to come to Memphis for a long time. Mr. Rauschenberger says that they search long and hard to find you. Are there other business groups that are against this proposal that you're familiar with?
I don't know what he means by long and hard. When the project began in 2000, the Direct Marketing Association submitted 30 suggested reform proposals, and I met with the leaders of the organization at that time. Of the 30 proposals that were recommended by the Direct Marketing Association, only one was adopted. So we haven't been hidden.
Other than the Direct Marketing Association, are there other business or commercial groups that are in opposition to this? He said that you were kind of a singular.
There are, and I don't speak for them. Some of them are in the room today.
They are in the room.
I believe so. I've been talking to them. I haven't looked behind me while I've been questioned, but they were here earlier today.
Well, some of them are nodding their heads. We'll figure out who they are later. I appreciate you, and I really appreciate the work of the NCSL, and NCSL is well represented here. And there's two of your predecessors, I guess, were Bill Claybo and Matt Kisbert, and they were great state legislators and did a good job, as you have, Steve.
Gentleman yield back.
I do.
Gentleman yields back his time. There is sufficient interest on the part of members of the committee in a second round of questions.
I think actually this is still the first round of all. I may not participate in the second round.
I apologize. You are correct, Mr. Cannon. You are recognized for 5 minutes.
Thank you, Madam Chair. I appreciate you all being here. This is, we appreciate Ms. Wagner, the update. I think that's the only new thing that is on the table today, and that's appreciated. And Mr. Isaacson, you said it all very well, and frankly now, Mr. Rauschenberg and I probably need to go back and forth a little bit because we've had the same discussion many times, and to suggest that there's error in your thinking, I think is appropriate. Personally, we've looked at all the data, I think, and we have not seen errors in your presentation. That was very concise. I think this is probably the fourth time you've made a presentation like this to this committee, and that was by far the most elegant. Not new particularly, but well done. Now, let me see if we can get some basic consensus on issues here. And I do this in the context of many other hearings, but do we have a basic consensus among the panelists, for instance, that the internet is one of the major drivers for economic growth in America? Ms. Van Wagenen?
I would agree with that.
Agreed.
Absolutely.
Well, we have unanimous view on that, which is good because that means we're all in America, we're all recognizing what's going on. Is there unanimity on the idea that there's a tendency for ideas on the internet? Remember, we have these hierarchies. You've got business to business where you're getting taxes paid, and I think Mr. Isaacson laid those out. I don't think there's much disagreement with that, but in the environment where you're getting new ideas on the internet, is there any disagreement by anybody on the panel that the tendency of those new ideas as they succeed is to become multi-channel, which means they tend to become not just clicks, but clicks and bricks? Ms. Van Wagenen?
I think they're going to continue to be a rise in the number of pure internet retailers. The figures that I saw in the New York Times last week.
Pardon me, I agree with you on that, but let me just, the question is, as you get this increase in retailers, is there a tendency for those to move, as they become successful, is there a tendency to move into bricks so that you have nexus?
And I would not agree with that. I think we've seen a number who've registered that are in that situation where they're multi-channel clicks and bricks, but there's many out there that are going to never adopt that model. So I would dispute that.
Could you tell me, what is it about those that means they won't adopt the model?
They don't want a brick and mortar store. They like to remain pure internet sellers.
But if they succeed and they brand themselves, won't they tend to want to become
I don't think you can
multi-channel?
state that universally. No, sir.
Oh, no, this is not, no, this is not universal. This is, I'm suggesting there's a tendency, I think I used the word trend or tendency, for successful stores to go multi-channel.
I think the trend is that the stores that are successful, the most recent one that was announced in the paper was like Cabela's, which have separated everything. They're going to multi-channeling so that you can return the goods in the stores. So if you have a store there, the tendency is to adopt that. But that you also have to understand that that's not going to solve your tax problem if you have a
We're just
growth
looking
in
for broad
internet.
consensus on trends here. And Cabela's, of course, is a great example because the fact is and I think Walmart was probably the first that tried to have separate channels and then went back to emerging because people want to return their items to a store. It's easier to return to a store than it is to put it back in a box. But that would argue for the underlying trend. Now, you may have boutique operations forever, but an operation that has less than $5 million in revenue is exempted, so you don't care about those little guys.
Well, Amazon doesn't have a store that I'm aware
Amazon
of.
is one of the uniques, I grant you that.
And they're huge.
Okay, well,
So I
let
think
me
there's
just say-
two trends, sir. That's my point.
No, the point is not that all stores will become multi-channel, and clearly Amazon is one of those very interesting cases where they are struggling and trying to figure out where they're going. They are competing with companies that have advantages because they have clicks and bricks. And so Barnes & Noble is a place where you can go drink coffee and read a book and then decide to buy it. Barnes & Noble is a place where you can just stop on your way to work and pick up a book if there's something you wanted to read. So there are advantages both places. Mr. Zakrzewski, let me speak
Close enough.
do you pronounce the Z?
Zakrzewski.
Do you pronounce the second Z?
Zakrzewski.
Zakrzewski, okay. Mr. Zakrzewski, do you agree that there's a broad trend to go multi-channel, and therefore, if you're successful on the internet, to create bricks as well as clicks?
What you've described is stores like Barnes & Noble, stores like LL Bean, Eddie Bauer, and stores that began as bricks going to clicks. I'm trying to sit here and think of an example of a pure internet retailer, though.
Well, actually,
that has
Eddie Bauer was a catalog that went to internet and then went to bricks, I think, after they went to the internet.
They had a store.
Okay, I can see we don't have broad consensus on this.
I don't think you do.
Let me just say that it is my view of the world that that success in American market, this debate could go on eternally. I see that my time has expired. I will reserve the right to participate in the second round if new issues arise, Madam Chair, and I yield back.
I thank you, Mr. Cannon, for being so cognizant of your time.
The chair could have poked the ranking member, and I would have recognized sooner that my time had expired.
You were just over the 5-minute mark. We're not going to hold it against you. There is sufficient interest in a second round of questions, and I will recognize Mr. Delahunt for 5 minutes.
I'd like to follow up on the perspective that was implied in a question by my friend from Utah, Mr. Cannon. And we're talking about Eddie Bauer, we're talking about LL Bean. You know, I have a concern for the small independent business that I think adds something to the community. I'm not saying that Eddie Bauer does not. I'm not saying that Barnes & Noble doesn't. But there's something more than just the economic factor in this particular equation. As I said in my opening remarks, I think this is, Norman Rockwell, hometown small business protection act. I really do. If we're going to have a space for the continued existence of that kind of entity that I think is a significant piece of what we know in terms of the American experience, how are they going to compete when they are put at a competitive disadvantage ranging from 3, 4, 5, 6, I think it's 8% down in Florida? Mr. Rauschenberger.
I think your point's well taken. This bill, your bill, levels the playing field and makes the Amazon.coms of the world play by the same set of rules that the Open Hearth bookstore in a little town plays by. What's more, it also, for the first time, obligates states to pay reasonable reimbursement, reasonable compensation to businesses for collecting their sales taxes. I mean, those are two important strides forward. And very quick, we don't know what the products that are going to be in the marketplace 3 years from now, let alone 30 years from now. So this is exactly the right thing to do.
One only has to look at the economy in terms of mergers, acquisitions, consolidations, et cetera. I think we lose something as a society when I can't go into the local drugstore anymore like I did when I was a child and go to the soda fountain and sit down and communicate with Mr. Johnson and have him ask about, how's mom and dad? That's not happening today in this country, and I think we miss something as a result of it. Mr. Isaacson spoke about, core constitutional or erosion, if you will, of core constitutional safeguards. I mean, Secretary Wagner, I read the Quill decision, and it said to me, Congress, do something about it. Can you explain to me, do you have a understanding of the constitutional erosion of core values?
I think the Supreme Court was very clear in the Quill decision, saying that when simplification and the burden is removed, Congress can require that. In fact, the Supreme Court threw this back in your lap. And I think we've come to you today to say we have achieved those simplifications. We can certainly achieve more, but we have a functioning board. We have a functioning process. We have gone a long way, and it's time to recognize that you make the burden across all businesses equal, large to small. So yes, you're right.
Again, Secretary Wagner, and any panelist, I keep hearing about how complicated it is, 7,500 taxing jurisdictions. To be perfectly candid, I think that's foo-for-all. I'm hearing from what you're saying is one simple reporting form. Don't give me that when somehow you've done it and people are voluntarily complying.
Yeah, well, every one of those sellers uniquely has a zip code, which is the source of the taxing. The states have agreed to match every zip code to a tax rate. So the question of one rate or complications or allowing states to sovereignly decide to allow local governments, municipalities to impose sales taxes is over. It's no more complicating than saying, do you realize members of Congress vary by height by more than 7 inches?
But, and at the same time, and you made the point, you're taking the burden of the cost of collection away from the remote seller. Am I accurate?
Yes.
I mean, I guess I'm frustrated. I've been, involved in this particular issue for 7 years. To me, it just, well, I don't know. Does anyone have an opinion on the small business exemption? Because this is a small business bill. And Mr. Isaacson, I presume that Mr. Cannon's going to give you some time, but I'm not.
And Mr. Delahunt, your time has expired, but I will allow the panelists to answer.
Oh, thank you so
Question
much.
that you
The
just posed.
question is, we do have the small business exemption with, which would require business in excess of $5 million nationwide and gross taxable sales in excess of 100,000. Would you alter that? Would you tweak that? We're open. I mean, I'm trying to protect small businesses in this country. I want them to continue to exist and be able to flourish and grow and to prosper. Can we help?
I think the small
Secretary
business exemption is important to have. Whether it needs to be stated in the congressional act as to exactly what the limit is, it could perhaps be decided by the governing board. You could put that in Section 6 of the bill and then let the governing board adjust that exemption as economic times change. But I believe you need to protect those small businesses, and there are several ways to get around it. We've had proposals come before the governing board about what ought to be that de minimis rule. I believe the governing board's the best place to have that debated.
Thank you, Madam Chair.
Thank you. The gentleman's time has expired. Mr. Cohen is
Thank you,
recognized for 5 minutes.
Thank you, Madam Chair. I'm going to go back to Mr. Rauschenberger and ask him to edify me on things I should have known. This whole thing with origin and destination, that's a Tennessee issue too. That hadn't been resolved, has it?
Unfortunately, it's the nexus, it's the point of most of the problems. If a state chooses to source the sale at the location of the seller, there's no way to avoid the seller moving his presence or his official office to a non-tax jurisdiction. So every state that has a traditional historical origin, retailer-based sale origination is going to have to adjust that if you're going to solve the problem of remote sellers. Because sales taxes, unlike what some people may think, are not imposed on the seller. They're imposed on the purchaser and collected by the seller. So states should have to go through some measure of political pain and reform. You can't have reform without change. But sourcing is going to be tough for all states. It's California's challenge, it's Illinois' challenge, and in part it's Tennessee's challenge. But if you don't move the sourcing of the sale to the address of the buyer, you can't get at the fundamental inequities because the seller simply moves his website, his mailing address to the Cayman Islands.
What my memo says is that Tennessee wants to have a origin rule or a portion origin rule. How would that differ from the destination rule?
The streamlined sales tax in one of those 170 or 140 amendments that they're considering, which are good because that's how we debate in the process, are considering what might be a bifurcated rule where the sourcing for sales that occur both from an in-state seller and an in-state buyer would be sourced on an origin basis, but sales originating from outside of the state's jurisdiction would use a destination source or a bifurcated rule. The fundamental problem with that are two things. Number one, there's a question of equal protection under the U.S. Constitution. Can you treat different sellers in a different way under your law? There's a question there. Joan probably, or Secretary Wagner probably is better expert at that than I am, what our chances are there, as well as there's some question of in states which have multiple rates, whether they'll have to adopt a blended rate or one rate for all incoming sales.
So are we talking about more of an intrastate sales issue?
Yes.
I can see where Tennessee would have a problem with that.
And the solution is elegantly simple, but really politically difficult. So it's normal, it's right, the states are struggling with this. But
the other issue, apparently there are 19 simplification requirements in this bill, and my notes inform me that so far 6 have been met. Is that accurate? No? How many have been met?
All but one.
All but one.
And the issues in resolution, dispute resolution is the only one we've not addressed.
Okay, well, that's good. For a minute, I was concerned y'all weren't doing any better than she and the Sunni. 6 and 19, but that's good. Thank you. I yield.
Gentleman yields back his time. Mr. Cannon is recognized for 5 minutes.
Thank you. Let me just make one point for the record. The political problem in a state for adjusting between the source of the sale and the destination of the sale is that often cities have created incentives for big box companies, and instead of the sales receipts coming to the city that gave those incentives, they go to the city from where the person came to buy. So rich cities end up buying more stuff from big boxes and getting more money, and the other cities end up tending toward bankruptcy, which is one of, I think, the fundamental problems. I suspect, by the way, that the current governor of Utah, Governor Huntsman, opposes the SST. I'm not sure he's been on record with that, but we certainly have moved in the other direction in Utah. We've talked a lot about the leveling the playing field. The fact is the playing field is level unless you disagree with me, and raise your hand or something if you do. The cost of delivery pretty much, wait a minute, let me get the statement out, the particular, let's get the particular out so you're not particularly disagreeing. I know that there are some interests here. I know that I'm astonished at the idea that this would be called a small business bill, when we have JCPenney's here and we have Staples pushing this and other companies around the country. People that want this done are people that are working hard to create a rigid system where they can continue to succeed. But the cost of doing business on the internet is greater because it's on the internet. So you have a delivery cost which is roughly equal to the cost of sales. That is not 5 minutes, was it, Madam Chair?
No, I think we've...
Is that not true, that the cost of doing business is relatively equal because the cost of delivery is more or less the same as the cost of tax for an internet company?
That's not necessarily true.
Well, how far off true is it?
Well, I mean, it's going to depend on what the individual business model, but you've still got to deliver goods to the customer through a store or through...
Well, that's right, because the customer walks into the store. That's the point.
Well, but you've got to
there's
still a delivery cost built into the cost of goods that you can sell in your store.
Sure, but when you deliver a truckload of goods to a store, that's not the same as delivering an item to a buyer across the country.
But it's not true that there is a pure additional incremental cost for that delivery charge.
Oh, wait. You're saying it's not true that there's not a clear delivery cost for an item that is sold online and shipped across the country?
No, I'm saying that it's not true that there is a pure difference that's equal dollar for dollar to that delivery cost.
But we're talking about more or less here, but we're not talking more or less, we're just talking about the cost of delivery. You would not disagree that there is a significant cost to deliver something that has been ordered on the internet.
That's true.
Oh, thank heavens. We got some consensus here. Amazing. Is there any disagreement that if we did an SST, Interstate Compact, that would create the second biggest tax collection agency in the history of mankind? The federal government being the first, Steve. No?
Doesn't contemplate it at all.
Who's going to collect the taxes?
The states.
50 states, the same ones collecting.
No. The SST is going to collect and distribute the taxes.
No.
Oh, no. Explain to me how this works. In fact, Mr. Isaacson, you've been very clear on these points. Would you mind explaining how it works? I think they may learn something in the process.
Well, you're going to have 7,600 different tax jurisdictions that are now going to be allowed to administer their tax systems in 49 other states. And so you are, in fact, going to create one of the largest and most complex tax systems in the world, and perhaps it will be one that challenges the federal governments.
Well, Mr. Rauschenberger, please do respond, but briefly.
I don't know where he's been, because that's not what it does. the city of Elgin in Illinois is not booking its way out to Land's End or to LL Bean to tell them how to manage
But
their
they're
store.
part of
If you
this
source
big
the sale to my
complex
zip code,
or
all
what
it's
you
going to
reclaim.
tell you is 6.75% is my sales tax rate. Collect it and remit it. I mean,
And where does he remit it?
well, it depends
does the
whether he
dealer remit?
chooses, if LL Bean chooses to hire a certified service provider, the service provider assumes the liability and does all the collection and the remittance and the tax forms for them at no cost. If he chooses to adopt a certified software, he would collect the seller's discount, the reward, the compensation for doing it, and he would collect and remit.
Thank you. I suspect that what would really happen in this context is that we would tend to homogenize sales taxes, and I find that disconcerting at least. Governor Spitzer just essentially called this a tax, or called taxing internet sales a tax increase. What we're dealing with here is, in fact, taxes that are taking more taxes out of the pockets of consumers. You know, one of the things I just don't understand, let me put this on the record, I've talked to many individual state tax commissioners, and we've had, I think, pretty broad consensus. It seems to me that the interest of the states is to encourage an environment, which has made them flush, by the way. Virtually all the states are flush with cash. It's created an environment of economic growth. The internet does that. Why would you want to poke the baby in the eye as it's beginning to grow? That's one of the facts I can't understand here. I understand how, as a group, states would want to tend to do this. But individually, if they thought about it, there ought to be a tendency to say, we have a great economy that's growing. Let's encourage innovation online. And
Mr. Cannon,
oh, no, it actually has expired, hasn't it?
your time has
Thank you.
expired.
What remains, I yield back.
Good time, so we'll put that in the negative account, and we'll charge you for that later. We are being summoned across the street to vote, but I do have one quick question that I think will clarify a statement that Mr. Cannon just made. So recognize myself for 5 minutes, but won't take that entire time. Mr. Rauschenberger, I'm particularly concerned about the statements similar to the ones that Mr. Cannon just made about people thinking that this is a new tax on consumer. And can you please clarify exactly what the SST does?
The enemies of this reform in states across the country, and you will hear, I think, in Congress, that this is a tax increase, but nothing, in my opinion, could be further from the truth. These are taxes that the Supreme Court says states legally have the right to levy, and they have the right to collect as long as there's reasonable notice to the seller. We've cured the increased bar that Bellis Hess and the Quill decision raised of simplifying our system so that it is not a burden on interstate commerce and crossing that threshold to be, hopefully, to be blessed by Congress. So this is about, I mean, the same argument could be used abolishing the IRS and not requiring people to mail in their tax returns.
Mr. Rauschenberger, I wouldn't go there because there are members who would be in favor of doing exactly that.
Well,
If I could figure it out.
These are legally levied taxes that are due from the customers. Sales taxes are not taxes that are unpopular. They win referendum time after time. When local governments, in the state of Michigan, when they chose to change the way they funded education, by referendum they selected the sales tax. People perceived the sales tax as relatively fair. It's less regressive than property taxes because at least it's indexed to the amount of income because you spend more as you earn more. So it's not a tax increase in any way that I can agree to.
Thank you, I appreciate that. I will yield back my time, and I want to
Madam
thank...
Chair, may I ask unanimous consent to introduce 2 articles into the record? One, an AP article entitled Spiked Clarification in Tax Law Aimed to Collect from Web Sales, and one from Forbes, Point, Click, Pay Tax.
Without objection, so ordered. I want to thank all of the witnesses for their testimony today and for being patient during the interruptions with votes. Without objection, members will have 5 legislative days to submit any additional written questions, which we will forward to the witnesses and ask that you answer as promptly as possible so that they can be made a part of the record. Without objection, the record will remain open for 5 legislative days for the submission of any additional materials. And because this is the last planned hearing of the subcommittee before the winter recess, I want to take this time to thank my ranking members, the members on the dais, and their staff for all of the hard work. And I want to wish everybody a safe, happy holiday season. And with that, this hearing on the Subcommittee of Commercial and Administrative Law is adjourned.
Good seeing you again.